Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. Today is June 25th, Thursday. Time for our conference call bi-weekly. We do it every other Thursday. We welcome everyone who's participating. As usual, as you folks would know, I go through the questions that have been posted before, take their follow-ups, and time permitting, do new questions. So we'll do the posted questions first. While we are conducting the call, I am monitoring my Twitter account. Okay, so if you have any comments or questions, the easy way to get to me is the Twitter account. You can, our Twitter is immigration.com without the dot. Immigration.com, that's my ID. You can also go to immigration.com on the home page. On the right hand side, there's a Twitter feed, as is the Twitter feed on the forums as well. So if you go to forums, there also you will have the Twitter feed on the right hand side. You can tweet to me while I'm doing these questions. I'll keep monitoring my tweets. All right, let's get started. First, let me do the frequently asked questions. The first frequently asked question is simultaneous filing of H1 amendment and extension. Well, let me make one thing clear. Filing for two benefits, for example, H4 and F1, F2 or F1 or even H1, becomes problematic when there is a change of status involved. Okay, so if you are applying for two different statuses at the same time, that becomes problematic. If, on the other hand, your status is H1, it's the same status, one is in the amendment mode, the other one is in the extension mode, I don't see it as a problem. So whether your amendment gets done first and extension gets later, or the other way around, I do not see how that makes a difference. As long as your status is being maintained, I do not see any problem with having simultaneous filing of H1 amendment and extension. There is no question of the application of the last action rule. Really, it doesn't matter if the amendment comes before the extension or transfer comes before the extension. It's your choice. You can stick with the same employer and join new employer later when their transfer approval comes. So it really, last action rule has little bearing on this. Okay, so I think that covers the first 3 or 4 questions that Victor 25 had. Let me just make sure. All right, the last question is also, does the current suspension of H1B premium processing apply even for the H1B transfers? Okay, what the government has said is we will not do premium processing where you request an extension, whether the extension is with the same employer or with a new employer as a transfer. So extension cases will not be processed in premium processing until government says otherwise. I also want to point out to you that we've received our first H4EAD approval, came in less than 30 days and without an RFE. So government seems to be hustling and moving real fast on approving the EADs, which is good news for all of us, I guess. All right, folks, anyone has any follow-up question on what I just discussed? No new questions. Any follow-up question, press *5 on your telephone. *5 if you have any follow-up question. Okay, let's go on to the next frequently asked question. Oh, there is one question. All right, let's deal with that. Maryland, go ahead with your question, please. Maryland.
Hello?
Yes, sir, I can hear you fine.
Hello? Yeah, you see, now you have asked for H1 transfer to new employer and also H1 amendment, B amendment.
Right.
So, if H1 amendment comes late, there is no issue?
No, there is no issue. Because let's analyze this situation. You've asked for H1B extension and you asked for H1B transfer. Am I correct?
You're right.
Okay, so let's say the transfer comes first. Even though the transfer is approved, it does not nullify your existing H1. That's the interesting thing about H1s. So you are working for IBM, Sun Microsystems got your H1 approved. You can still continue working with IBM and join Sun Microsystems in a little while. As to what the timing should be, let your lawyers help you with that. There are some issues there that need to be discussed and sorted out. So, but it's definitely okay for you to continue working for IBM.
No, the real practical problem here I am having is H1B amendment IBM is filing.
Right.
H1B some transfer other employer is filing at the right same time.
Sure, that's no problem. That's what I just explained to you. I said if both are filed at the same time, if the transfer comes first, no problem. You can continue working for IBM. If the extension or amendment comes first, you can still continue working for IBM. You can join the new employer sometime after any approval or with the receipt. There are many permutation combinations, but there is no conflict created by two of these at the same time. Okay?
No, no. I'm not able to explain to you my situation. Please, Rajiv, excuse me once again. I will tell her. Please.
Okay.
You see, presently I am working with Sun Microsystems, and they are going to apply for my location change, which is August 19th.
Okay.
And also, I got an offer from Google.
Okay.
So they are also applying for my change.
Okay.
Transfer.
All right.
So if H1 transfer is coming first, and then H1 amendment of Sun is coming later, I can join Google, no problem.
No problem at all.
No problem at all.
Yeah. What I one second, sir. Let me clarify something to you. This multiple applications becomes an issue only where there is a status change of status or multiple statuses involved. So somebody is on H1, they are applying for F1 as well as H4, becomes complicated. Okay, but where there's an H1 amendment, extension, transfer, or three transfers pending, no problem.
Okay. So I can shift even though H1 amendment is pending.
Yes, no problem.
Okay.
All right.
Okay, thank you.
You're welcome. Good luck. I know it's complicated. When I was in law school many years ago, I was advised that in United States, the three most complex bodies of the law are tax, the Internal Revenue Code, Security Exchange Commission regulations, which is how stocks are traded, and the third is immigration law. So these are very, very difficult areas of the law, very complicated, and they change extremely frequently. As you will notice, I will have a comment about the I-140 priority date issue. This is a change in position from USCIS, which is going to affect a lot of people. Okay, another frequently asked question before us is green card through a future job. Okay, I'm working for an employer or I'm outside USA and an employer in the United States is going to apply, or another employer other than the one I'm working for is going to apply for my green card. Is that allowed? Absolutely. It is allowed. What are the requirements? There is really only two or three things that have to exist. One, I, the employee, have the good faith intention of taking that job. Interestingly, I'll explain a little bit further. You may never have to join that job, but you should have the good faith intention. You must have the good faith intention to take up that job when the green card comes through. You may never have to do it, but you should have the intention. Number two, the employer must have the same good faith intention of hiring you sometime in the future. What is that time? Either a commercially reasonable period after you get your green card or any time before that. So let's say you get your green card approval today, the future employer should hire you within 3, 4, 5 months. That's a commercially reasonable period. Okay. What if they don't? Would you lose your green card? Probably not. That's an entirely different story. So I won't get into all of that. Question before us is applying for a green card through a future job. Can it be done? The answer is yes. Employer should have the ability to pay wages. That's an important thing. Other than that, all that is needed is the good faith intention on the part of the employer and the employee to give and take the job. Okay. So There is a misunderstanding from Kiran007 who's posted this question. They said, my understanding is as long as my current job description and the one that company A, which is the future employer, um, matches, that would be okay. There's no requirement that there should be a match between your current job and the future job being offered to you. That is incorrect. Okay. Um, what do you need to worry about? Not much really. And remember, AC21 portability applies even to future jobs, which means once my I-140 is approved and 485 has been pending 180 days, I can join any employer, never having joined the future employer. Okay. Well, let me open the floor for questions. Star 5 if you have any follow-up questions. No new questions, only follow-up questions. Star 5. Green card through future employment. Any questions? Star 5. Star 5. Okay, nothing. Let's move on to the next frequently asked question. I usually go in and label them. Here is one. What if my employer doesn't pay me? I'm on H1. Well, the employer will be in a lot of trouble. The law is employers cannot bench or reduce the salary of the employees just because they're in between projects. The employer is required to pay full salary. Okay. If they don't, you can file a complaint with the wage and hour division within a year of when the wages were not paid. Department of Labor, Wage and Hour Division. Just do a search on any search engine for Wage and Hour Division complaint H1. It should bring you the result. I think the form is called, I want to say WH4. That's the form you use to file a complaint. And the way it works is once you file the complaint, Department of Labor then investigates it. You have to do nothing. It doesn't involve any expense on your part. I've seen lawyers telling people that you need to hire a lawyer to get your money back. Not true. For H1 holders, Department of Labor will recover the money and they will get the check sent to you. So that's one thing. Second thing, if the employer has the practice of doing it on a routine basis, that company can be in a lot of trouble. Please do not get involved in a situation where the employer runs the payroll and then you return the cash to them. If that is a situation anybody invites you to, that is a party to a fraud. Do not do that. Fraud and misrepresentation it can result in criminal prosecution, and it can also result in a permanent bar from entering the United States. Do not get involved with something like that. Anybody has a question about employer not paying on H1, press star 5. Star 5 on your phone, please. Any follow-up? No new questions. Okay. Let me move on to the next. This is also a very frequently asked question. TN applying for a green card. So if you are a citizen of Canada, you are in the United States on pre-national visa, which is referred to as TN visa. Can I apply for a green card? The answer is no. There are two kinds of non-immigrant visas. Those that absolutely do not allow you to file a green card, like F1 visa, tourist visa, and even TN visa. And those that are referred to as dual intent visa. Even though you are on H1, L1, H4, or L2, you can apply for, or even O1 or O2, you can apply for a green card. It's allowed because these are dual intent visas. Okay. So here is what we recommend our TN clients to do. What exactly is the stage after which having applied for a green card becomes a problem? Let's look at that. Applying for PERM is not a problem, because the issue is if you apply for a TN extension or you go to the border and are visiting and coming back, the fact that you applied for a green card can become a problem. Government can refuse you entry, then you have to apply for an H1 under the quota and be a part of all that rigmarole. So the interesting thing is green card, according to USCIS questionnaire, begins at the time of the I-140 filing. So you could time your TN application extensions and visits, and you could time everything so that you don't have to apply for an extension or visit outside when the I-140 is being processed. And if you are born in a country other than India and you're an EB2 filer, you should be able to apply for I-140 and 485 at the same time. That will get you both work authorization as well as advanced parole, permission to travel. That way TN will no longer be needed. Okay, so let's just review the questions. Ramesh says, I need to be on H1 to file for my green card. Assuming I-140 is approved, will I be able to get back on a TN visa? See, the problem is once you have exhibited immigrant intent, it will be difficult, not impossible, but difficult to get back on TN visa. So rest of the questions are really not quite, they don't really require a whole lot of application, explanation. The issue of whether you apply within USC or apply at the border is irrelevant. You're going to have similar problems if you have an I-140 going. Okay. Anyone has a question that's a follow-up on TN applying for green card, press *5. Follow-ups only, no new questions, please. *5. Okay. Let's move along. TN applying for green card. Let's get to the next set of questions. Oh, there was a question about accepting some benefits on maternity leave. Briefly, let me tell you that anything that's a means tested benefit, means tested means that depends upon your income. A means tested benefit from state government or federal government could lead to immigration problems. I have put a link here to my blog entry on this. Go ahead and review this. This question should not require too much discussion. Okay, I'm done with the frequently asked questions. Let me begin on the other questions posted in the order that they were posted. So the question number 3 is from R. Sharma R. I got my I-140 approval with employer A under EB2. Was working for them for client B, a Fortune 500 company. So I guess B is the end client. So you went and joined B, but employer A did not revoke your I-140. Good. You worked with B for 2 years, then they laid you off. Client B's H-1B was approved for 3 years based upon the I-140 approval. You went back to the employer A, who did your I-140, and now you're working for another client. Okay, but you got an you joined client and then you got an RFE, replied, job is exactly the same as in PERM. Employer A's head office is in New Jersey. When I applied for green card, I was working in New Jersey, and PERM and the I-140 was approved, and you were in New Jersey. Currently, you're working for employer A in Georgia for client C. Okay. Employer A also has an office in Georgia. Okay. Well, let me cut through the entire history to make it very succinct and brief. I was working for an employer A who are in New Jersey. I-140 approved. I joined A's client. I had to leave them. Okay. I rejoined employer A who started my green card, but I joined in Georgia working at a client site. And as a matter of reference, employer A also has an office in Georgia. That is the sum total of your scenario. So the question is, my priority date is Jan 2011 in EB2. Will this be a problem because I'm working in Georgia? Look, we just discussed green card through future employment. The same principle applies here. There are 2 ways consulting jobs are saved. One, because consulting jobs often involve travel, we usually, as directed by the US Department of Labor, file these jobs from the corporate headquarters, no matter where you are located. So either the jobs should be filed through the corporate headquarters or the principal place of business. That way, no matter where you are, your green card is secure. That would be the way probably your lawyers would have filed it. So having currently moving to Georgia does not present a problem. Second way Georgia angle can be covered is if it is your intention to rejoin New Jersey and the employer's intention to take you back in New Jersey, where you are working currently doesn't matter. So how your green card is protected, either it is through one method or both these methods, you have to discuss it with your lawyers. Okay. You shouldn't have to file anything from scratch. And the wages are higher, lower, none of this is really that relevant. Can you hire your own lawyer when applying for 485? You can, because 485 is your application, not the employer's application. Okay. Let me move on to the next question. This is from Bhaskar D. PERM questions filed in September 14th, 2015. It's under audit. H1B is expiring in July. So September, I'll be okay from July onwards, but I've got 70 days to recapture. That means July 29th to about August 28th, and add another 10 days. That brings me to about September 7th or 8th. Still 6-day gap between September 14th or 13th when my next 6 year kicks in. Well, remember, you can combine the recapture and the 1 year extension because of the 365-day rule in one application. Please do not do it yourself. Get your lawyers to file the H1. It is not a good idea to have your own H1 applications filed. There are some serious consequences to H1 filings. Okay, this is not a simple application like a tourist visa application. Okay, now because you have a 4, 5, 6 day gap probably in the continuity, that you can do one of the two things or three things. You could, like you think, change status for 4 or 5 days to B visa, or you could spend another 4 or 5 days. Just go to Canada for 4 or 5 days and come back. Because under the law, if you are outside USA for another 4 or 5 days, you can recapture them also as a part of the same process. Okay. Interestingly, any visits to contiguous territories are Canada, Mexico, New Virgin Islands. Any visits to these territories do not require you to get a new visa stamping. So you can travel on your I-94. That procedure is called automatic visa revalidation. You can search for that term, automatic visa revalidation. Spend 4, 5, 6 days extra outside. You can combine everything together. You have an H1 going all the way to September 2016. Okay, so that would be the smart thing to do. I'm not going to answer your questions about new LC and all. You need to get a lawyer. Don't do that yourself. Next question is quite complicated. I do not know all the answers. This is from Kum Shakti about green card, naturalization of a child born outside USA to parents, one of whom is a US citizen, the other one is a green card holder. This is what I advise you, sir. Go to USCIS website. This information is on our website also. Look under naturalization or citizenship. You will see there is a specific set of, there are actually tables that deal with this situation. Okay. If I were you, I would want the child to be born in USA. Is there any great advantage? Well, really, the only big advantage to a child who's naturalized and a child who's born in USA is that things like they can't run for office of a president if you're not a US born citizen. Okay, it's a minor issue, but it's just, I think personally, I don't know why, but I always prefer that. So if you have the choice, I would prefer that the child be US born. That's what you want to do. Okay. Your other question, which is more important in many ways, how long can be the wife outside USA who's a green card holder without having any issues for her green card? Look, any visit outside USA, even if it is for 2 days, where a person has abandoned their permanent residence, can lead to loss of green card. Okay. Number two, If there is no abandonment of permanent residence, it's a temporary visit. If it is less than 6 months, it usually is no problem at all. More than 6 months, less than 1 year, you can be questioned, grilled very thoroughly why you were gone, have you abandoned your residence, etc., etc. A year or more, you lose your green card presumptive. One way around that is to file for re-entry permit, which allows you to stay away for up to 2 years. Re-entry permit, okay, Form I-131. Read those instructions. Next question is Vinay, who says, wife is on maternity leave. This is the question I was answering. Can I take state-sponsored benefits? And I have posted a link further down to an entry on my blog. Read that, and that should give you some idea. Can a person on H-1B be paid by anyone else, state of New Jersey here, who's not their employer? I think there's another different issue, which is taking means-tested benefits. Is that going to result in a disqualification from immigration? So just be careful with that. Okay. Next question is Hari74. I am undergoing naturalization. Interview is scheduled on July 16th. I want to travel on the 18th. Well, wait a minute. If you're going to relocate for 2 months, you can have trouble during interview if you postpone the interview, because they are going to always ask you, since filing the application for naturalization, have you been outside USA? If so, for how many days? So they can grill you quite a lot about these things. My advice would be to not do this. Finish your interview, postpone your trip or relocation. Once you get your naturalization, you can relocate forever. Nobody cares, because under the rules, once naturalized, you can choose to live forever outside USA. So you're still a US citizen. Okay. Can I prepone my interview? I doubt it. Get your congressman involved. Talk to your congressman's office. See if they can help you. Can I request for oath on the same day? It depends upon the office. Some offices have such a procedure. Some offices do it in chunks. Bunch of people one day, bunch of people another day. Some people do administrative oaths. So just find out what the local process is. Again, congressman is the best bet. If I complete my oath, can I travel to India? The moment you take your oath, you are a US citizen. So you should get a US passport. Can you work in India? Indian law, I do not know. I only practice on the US side. Can I request oath after 6 months? Contact your congressman. I just don't like the idea of being outside for that long. They could treat your naturalization application as being suspect and not approvable because you are in the process of abandoning your permanent residence. Okay, so I don't like that scenario. Banyan Tree says current I-797 expired December 2014. H-1B extension was filed October. USCIS has brought out two RFEs. 240-day grace period will be up in August. Yeah, 240-day grace period begins after I-94 expiration. Okay, so whatever that time frame is. Will the clock be reset if another employer files? No. To the best of my knowledge, there is no such provision. I'm trying to think if the regulation reads any differently. I doubt it very much. I'll have to look at the regulation, but I don't think so. The USCIS is questioning the job responsibilities not being commensurate with the bachelor's degree requirement. Also, employer-employee relationship. Should I leave? What are the options? Well, you should fight it out. These are common issues. These are not issues that we are unfamiliar with. These issues come up quite frequently. As to what the strength of your response is, it's a fact-bound issue. I cannot comment about it until I actually see the paperwork. Okay? But don't just abandon it. These are common issues. Ashish 1802, I am on L1B, then on L1A. Employer does not want to file a green card. Can any other employer file a green card based upon future employment? I just answered that question in great length. Definitely, another employer can file for your green card. I hope you're on the phone, because if you have any follow-up questions, we can deal with them. Next question. I'm working in company A, work for the same company A as a manager, but you have less than 365 days outside USA, so about 21 days short. Um, can I work in India now and cover this remaining 21 days? I do not believe so. This should be researched because let's say you were working for company A. USCIS, I think, requires continuous 1 year. If there is a gap, it does not help that you go back and do another extra 21 days. I doubt it. I would have to research and see what the USCIS rulings on this are. And can we leverage the fact that you're working for the same group of companies? Because there are some exemptions in law for having worked for the same group of companies. Does that extend to maintaining continuity even though there is a gap because you're working for the same group of companies? I don't know the answer. But I do know they are very sticky about the 366 days. I don't even count it as 365. I count it as 366 days outside USA. So, in a nutshell, I don't have all the answers, but I believe this needs looking into. So, have your lawyers take a look at the law. Indeed. I'm monitoring my Twitter account, guys. If you have any tweets, tweet immigration calm while I'm reviewing these questions that I posted. Any questions or follow-ups, just tweet to immigration calm. You can also tweet from immigration.com, our homepage, or from the forums.immigration.com. On the right-hand side of both these pages, our Twitter feed displays, and you can send us tweets from there. Okay. Indeep says, my employer filed for my H1B, got my receipt. Oh, by the way, guys, those who just logged in, I wanted to inform you that we've received our first H4EAD approval. It took less than 30 days and it was approved without RFE. Good sign for all of us. Okay. H1 has been applied for. I do not have the job now as the company did some reorganization. I was earlier F1, OPT expired in March 2015. I also applied for change of status to H4 before filing for an H1B. So if you applied for H4 during the life of your F1, you are good. Okay. Some follow-up questions because I've applied for both H4 and H1B. I have both receipt notices but no approval. And actually, the person who was corresponding with me on Twitter, they said, I'm reading the tweet, question posted in forum referring to question 11 from Indeed for H4 change of status approved, waiting for H1 approval. So the H4 change of status is approved. Okay. But let's take these questions anyway. They might be relevant to the whole community. What if my change of status to H4 comes before H1B gets approved? Would it complicate anything? Well, it's a little complicated because when you applied for F1, for H1, you were on F1. So you requested F1 to H1 change of status. Now you become H4 holder. Does that make a difference? I don't think so. Something to clarify with USCIS, not a bad idea to give customer service a call. Even if they give you half-baked information, make a note of it, make a note of the date that information was given to you, and the officer you spoke with. Okay. So I don't think it should make a difference, but doesn't hurt to double check. If my H1B comes before H4, withdraw your H4. Is it possible to get an H1B transfer before October 2015 without joining the employer? This is very important. Last time we spoke with USCIS a few months ago on this issue. It's a quota case. It's a quota case and the quota begins on October 1st. I've got the approval. What if I want to change employers before quota kicks in, before October? And the answer is it can be done as long as the old employer does not revoke the H1. If they revoke the H1 before the second H1 is approved, government says that they consider the quota issue to come up again. That means they will not consider you to be quota exempt. Something like that. Double check with USCIS. You can have your lawyers check. Their thinking changes every few days because these issues are not written down. I always like to double check. Okay. Is it possible? Okay. Then next question is, if I travel to India and come back on H4, if I do not have a job, would I be able to reuse my H1B? Yes. If the H1B is not revoked after October 1st, even if it is revoked, as far as I know, you should be able to get quota exemption. Looking at this situation, would you advise that I apply for an H4 EAD before traveling to India or after I'm back from India? Hey, from our experience that I'm talking about today, they are giving us H4 EADs within 30 days or so. Why not apply for it now? That's the way I look at it. Okay, next question. GC Helps is working on H1B, planning to transfer to H4 EAD. What are the chances of getting them approved together? I can't predict that. The case that we filed, the person was already on H4. I don't think anybody can guarantee you simultaneous approval. Do I need to file H1B amendment even if I work for the same location but my salary is reduced? I believe so. If there is a substantial reduction in salary, there should be an H1B amendment. I'm taking maternity leave for 2 months. I don't think that's a problem. If you're getting paid less because you're on maternity leave, I don't think that should be a problem. I don't know what the laws on federal laws or state laws on maternity leave payments are. But if the employer, I don't think the law requires the employer to give you a paid leave. So if they are giving you a reduced salary for that time, I think it is my guess it should be okay under federal immigration law at least. Okay. Next question is from Venkat. I-140 approved in EB2 category, priority date 2013. I've got a good job offer from company B. They'll start the process in EB2 in less than a year after I join. Yes, USCIS is taking the position that if the I-140 is revoked, your priority date is gone. Okay, so you lose your priority date if the old employer revokes the I-140. This is the current thinking of USCIS. In fact, I looked at the regulations. The regulations seem to point in the direction of USCIS being correct in this assumption. Okay, so unless we see something drastic change, I think it's best to assume that you'll lose your I-140 priority date if the I-140 is revoked. Vinil says, if I'm over 21, I'm 26 years old, 28 years old, how does my green card application as a derivative come about? And the answer is, if you are over 21, you can only deduct from your age the time that form I-130 was pending. If the I-130 was pending for 7 years, you'll be able to come using Child Status Protection Act. But if the I-130 was pending less than 7 years, you would not be able to come in. You would have to be applied for separately. Okay, I hope that sufficiently clarifies things. CALM 20, pending AOS applicant, continuing to extend my H1B. I've used my advanced parole. Now, typically when they give you advanced parole, it's given for lesser time than your H1. That doesn't change anything. If you're working for the same employer, you are still considered to be on H1B. Okay, so the fact that you used your AP does not invalidate your H1B status as long as you are returning to work for the same employer. Then there's a fee issue. I don't really get involved with the fees issues. So somebody in my team can answer that question for you, but I cannot. I do not know if there have been fees issues like the one that you mentioned. So I really have no comments about that. Final question is about the job function change, I gather, on H1B visa. I'm working on a management degree, considering taking a job or opportunity within management consulting. Given that the new job profile is very different, can I have my new employer submit an extension to my current H1B? Yeah, H1B extension does not require that you have the same job or requiring the same skills. As long as the job is an H1B level job, requiring at least a bachelor's degree level education in a specific field, the fact that, what if I have 2 bachelor's degrees? Let's say I have, for instance, look at me. I have a bachelor's degree in science, okay? And I have a bunch of degrees in law. So I could go in either as a scientist or as a lawyer, and I can go from one to the other during an extension, no problem at all. Now, would you have to restart your PERM? And the answer is probably. If the job profile is completely different and you're not going to come back and work at the old job, you would have to start another case altogether. But because you're a pending AOS applicant, you could probably interfile your new I-140 after you do go through the new process. And if the I-140 is not revoked, use the same priority date. Okay. So yes, if the job that you intend to join is not the same job for which you applied the PERM, you'll have to start all over again. Bob, 87, applied for an H1 transfer, got denied. We don't know the reason yet. Informed the company attorney, they said, let's receive the letter and then take a decision. I want to know how I can stay in the US and get valid status. My first H1 was picked in the lottery in 2013, filed by company A, activated from October 13. Oh, this is a very long fact pack. Let me grab a glass of water, just a sip of water, and I'll get right back into it. Let me see what I can do with this. So, picked in lottery 2013. After 1 year, I got a full-time job with company B, H1 transferred. Started the receipt number. Before getting any result, left company B while the H1 was still in process. So transfer is processed, joined company C with premium processing. Previous H1 with company B, I guess, was approved, and now I have applied company C. H1 was denied, and we don't know the reason. Okay, so working with A, file for transfer to B, joined with receipt. While the transfer was pending, joined C. B got approved, C is denied. Got it. C has one prime vendor and one client, P and T. Okay. The RFE needed a prime vendor's letter, etc., etc. What are the options? What is my current status? Well, really, this is such a fact-bound question. Generally speaking, you are unlawful if your I-94 is gone. And if you're unlawful in USA for 180 days, you are subject to 3-year bar. Okay. Having filed a motion to reopen or an appeal does not stop the running of the unlawful presence unless the appeal and motion to reopen is granted. So that's not a risk you should take. I can't really say anything beyond that. I would suggest you sit down with your lawyers, and if the situation does not become clearer, go ahead and do a consultation with us or another lawyer. But this really requires going over your paperwork. I can generically answer these questions, but be very careful with the 3-year, 10-year bar. Okay. What are the options if I want to stay in the country? Really, you cannot. You would have to probably go outside and come on a new H1, keeping in view the 180-day period. How is it going to help if current company C reopens, reapplies the same petition? Not much. Just keep the 180-day period in mind. Other than that, if you overstayed by a few days or a few weeks, I don't think it is a major issue. We prefer that you don't, but it's not something, since you have a bunch of cases and processes going, USCIS would likely forgive you being out of status. But unlawful presence of 180 days is a bar that they cannot control. Okay. Can I join school? And the answer is, if you're out of status, which you appear to be, you cannot change status. Whether you get rehired, whether you try to change status, same problem. Okay. So I think that covers all your questions. But if you're here on the phone, have a follow-up. I can answer 1 or 2 more questions on the same issue. SVT Rajan says, PERM process. Company A started my PERM in 2012 for EB3, went into audit. It wasn't handled well. I changed my jobs, joined company B. Let me make something clear, Mr. Rajan. You do not get a priority date that can be transferred until PERM is approved and I-140 is approved. Okay. Fresh perm time, about a year or so, typically from the date of collecting your documents, year and a half is the perm time. Any restrictions about the employer, company who can file, as long as they can pay your salary, that's good enough. Is green card process possible for a future employment? I've discussed this issue in great detail. That's the first issue I discussed today. Okay. And let's go to the last set of questions. And then we'll start follow-up questions. After I do the follow-up questions, time permitting, I'll do new questions. It's the same set of issues about EB1C, multinational manager, and I said 366 days is what I like to see. It has to be with the sister company. 10 months experience is not enough, and if you go out and come back after 2 more months, I want somebody to look at the law on this because you're working for the same group of companies. There might be some dispensation or little leeway there, but normally you cannot break up experience for EB1C. They don't typically allow that as far as I remember. So it's worth looking into whether because of working with the same group of companies, there's some dispensation because it's the same group of companies on H1B. Try looking into it, try having your lawyers look at. You can retain us to look into it for you. But I don't know the answer off the top of my head. Worth looking into. Regulations should be looked at, and Administrative Appeals Office rulings should be looked at. Another IT Canadian citizen TN. So the question is, my end client does not want to sponsor me. Okay, my end client does not want to sponsor me. So can I get a TN? Let me try to remember. We just did a very interesting TN. Even if they don't want to sponsor you, okay? I think this is what we did with the TN we did last week. I'm quite sure these are the facts. We have a company in Canada, a company in USA. Company in Canada formed a contract with a company in USA that they will accommodate a systems analyst. They need a systems analyst. So then we sent our Canadian guy with a letter from the Canadian company. There were no petitioners on the US side, merely a contract and a letter from the end client saying that we have this job. And this is a corp to corp. So in that case, it is something you can think about. Okay. So it's not really a job offer letter as much as it is a contract between the companies. So you can definitely, Manu, you can think about doing a corp to corp, and maybe that would work for you. Okay, I'm pretty sure that's what we did just last week, actually. And here's a question from Caffrey. This is a very ill understood question, the Simeo decision. When are we required to file an H1B amendment? And if we have violations in the past, are they already forgiven? Well, don't be fooled by that. Let me explain to you. First of all, the Simeo decision is nothing new. Last 6 or 7 years, USCIS has had the following interpretation of the law. Any substantial change in your job requires an H1B amendment. Any substantial change in your job. What is a substantial change? Material change. Any change in your job description. If you're changing your job description, you're going from system administration to software engineering. One example. Okay. A change in your end client probably would require an amendment, even if it's in the same area. That's my interpretation, because the employer-employee relationship could have changed. Okay. If you go beyond normal commuting distance of a job for which you've been approved, you would require an H1B amendment. These are all material changes. Simeo decision says this. It says, if your job change is beyond normal commuting distance, of an approved location, you are required to file an H-1B amendment. All right. But what if within the same area your job description changes? You're still required to file an amendment. What if the end client changes? I'm having all our clients file amendments. I think this decision that they gave, the similar decision, is not really all inclusive. It does not cover everything. The basic idea is still, if there is substantial change in the job, you're required to file an amendment. Also take into account the fact that Department of Labor has its own regulations. So what USCIS says does not necessarily bind Department of Labor. So people who have issues in that there are violations, I would definitely want the employer to file for amendments and get that out of the way. Don't think just because USCIS is giving statements, which are, by the way, non-binding statements, that we will not hold you responsible retroactively. They can, because the regulations were always there. Similar decision came much later. It cannot overrule the regulations. Okay, so just bear this in mind. That's the way I view it. All right, let's go to the next question. Spouse was charged with liquor prohibition violation in the sting operation. Just remember one thing. There are two kinds of crimes. Crimes involving moral turpitude, crimes not involving moral turpitude. Assuming that this is a moral turpitude crime, we have to look at whether this was a misdemeanor, a regulatory violation, or a felony. Obviously, this does not look like a felony. But you need to talk with an Ohio lawyer where the crime occurred. If it is a misdemeanor, chances are this will not be an issue. If it's a misdemeanor, chances are it will not be an issue. Look into research petty, P-E-T-T-Y, petty as in small, petty offense exception. That's what this is called. Single misdemeanor all through your life is called a petty offense exception, and it is forgiven unconditionally. Okay, but bear in mind one thing. I'm looking at something here that makes me very nervous. You've got to make sure that you do not tell any incomplete facts or misleading facts to the government during the visa interview. Interestingly, even though I'm exempt because of petty offense exception, if I misstate an element of my case or lie about my case, I can be barred from entering USA forever. Okay, I would advise you to do two things. Check with an Ohio lawyer, make sure that this was a petty offense in the sense it's a misdemeanor or just a regulatory violation. Then check with an immigration lawyer, letting them know what the finding of the Criminal Defense Council in Ohio was. If it is the same individual who practices immigration law as well as criminal defense law, good. Otherwise, do two distinct consultations, just to be sure. But under no circumstances can you misstate anything. Okay. And the last question, in addition to my question number 4, when I apply for recapturing, to remind everybody, this is a question about recapturing 70 days, and there's a 4, 5, 6 day gap between when I can extend 1 more year. When I apply for recapturing 70 days, can I ask USCIS to extend? Or if there's no gap, you can combine recapture and the 1 year extension in the same application. You don't have to have 2 different applications. Okay. So even if there's a gap, so let's say if I recapture 70 days and ask for 1 year, combined 1 year and 70 days tides me over without any gap between my current H1 and the next H1 extension. Great, you can combine the two. Even if there is a gap, you can combine the two, but then for those 4 or 5 days, you would either have to go outside USA and recapture all of it in one go, or you would have to leave USA for 4 or 5 days. Okay, all right. Any follow-up questions, press *5. No new questions. Follow-up questions on anything we have discussed so far. *5, please, on your phone. Follow-up questions. No new questions. Three follow-up questions. *5 on any follow-up questions. All right. After the follow-up questions, I'll spend another few minutes doing new questions. Let's go to California. California, go ahead, please. California.
Hi, Rajiv.
Hello.
I'm the person who asked about the ROP on the extension.
Are you talking about the H1 extension and recapture?
No. The variant tree with I-797 expired. It's an 8-1 from the top.
8th question. Okay, let's go to that.
Yes.
Give me 1 second. Let me get there so I can refresh my memory. This is a 240-day grace period question? Sir?
I'm sorry.
Are you the banyan tree?
Yeah, yes.
Okay, I have your question. Go ahead, please.
Okay. Yeah, actually the USCIS actually they denied my petition right now as of yesterday or Tuesday. But I'm already the I-94 expired in December.
Okay, so that means that means, judging by what I know, again, your lawyers can best guide you, that your 180-day begins from the date of denial of your H1.
Okay. Right. So, so does it mean that I have to leave the country immediately?
Well,
what would be any options that are?
Look, if you have a motion to reopen pending or filing an appeal or something, I think you can. It's not legal, but if you stay, government is probably going to be tolerant of you staying. Hang on 1 second. I have some notifications on my Twitter account. Let me just make sure. Okay. All right. I will, Vikram, I will get to it in just 1 minute. You have some questions. Let me just answer the follow-ups first. Okay. So government is tolerant in my view. I have not seen anybody being harmed. But if you stay here 180 days and then end up losing, you will be subject to 3-year bar. Just keep this in mind. Okay.
Okay.
Anything else?
So I think since it's already, since it's another, just want to clarify a point. Since already, so the 180 days goes to the I-94 expiry date, right?
180 days in your case goes to the date of denial of the H1. If there is a timely filed transfer, timely filed extension, the 180-day begins from the date of the denial. But I want you to sit with your lawyers now that you know what to ask. Make sure that they calculate your 180 days correctly. Okay.
Okay, gotcha. So it's not the date of the I-94.
Not where there is a timely filed extension, transfer, etc., or amendment. Okay. If there is, if your I-94, hang on, listen to me. If your I-94 was expiring tomorrow, let's say we filed either an amendment or an extension or a transfer yesterday. It's received by USCIS yesterday. The fact that your I-94 expired the following day does not affect you. Your 180 day will begin to run from the date whatever benefit was asked for is denied. Okay.
Okay.
Good luck, sir.
Okay. Yeah, thank you.
You're welcome. Okay. We have 3 more raised hands. Let's go to Texas. Texas, go ahead, please. Texas.
Hi. Hi, Rajiv, sir. My case was, my name is Bob, 87, about the denial notice about the H1. And then what are the options if I go back to my previous employer? Because I have his approval and then the I-94 valid is up to 2016.
Sir,
and then
can
my
you
H1 was
do me a favor?
On Friday, last Friday.
Sir, do you have your question number?
Yes, my question 19 is my question number.
19. 1 second. Let
19.
me,
Yes.
let me get to it. Give me 1 second, okay?
Okay.
Oh yeah, you are the long fact pattern.
Yes.
Yeah, the A and the B and the C. Okay. You see, here's my problem. This is the way I look at it. When you join a company with the receipt and end up losing the underlying case, I think you're out of status. And I don't think you can go back and join anybody in the chain. That's my view.
Okay. So it is better for me to file a new H1 or MTR and then go back to India and then come back with the approval?
Well, do you have currently any H1 that is unexpired? Any H1 that is unexpired?
Yes, I have two. The previous one, the latest one, I do not know. I do not have the approval I-797 form, but I have the previous one, the employer A I was talking about, that shows up to 2016 September. It was valid, and then when I checked the case status online, it says
they have not revoked the H1 because under the law they're required to revoke H1s. They have not revoked the H1.
Does it show when I check the when I check the online status in the USCIS, it says it was approved and sent like back in 2013. It does not show anything like
I feel that the cleanest thing to do, I mean, there are things that we can try to weasel out, but the cleanest thing to do is just apply for another H1 and come back with a fresh H1.
Okay.
Visa. Come back with a fresh H1 visa.
Okay. Okay, and then if I come back when I go to the visa interview, he might ask me, right? What about the rejected case? What do I say? Like
you tell
if I open an FTR,
you tell the truth, sir. Just because one H1 has been denied does not cast shadow upon any future approvals, unless the denial was based upon a question regarding your degrees, etc. If the way the case was drafted was the cause, or the documentation that was asked for was not provided, that was the cause. None of that in any way interferes with your future H1s. Okay?
Okay. So opening an MTR and a new H1.
No problem.
Might be a wise thing to do. Okay.
I do not know the strength of your case, but MTR does not interfere with any future H1s either. Okay.
Okay. And then I still have that the 180, and then that starts from the denial date, right?
That starts from the denial date, but please check with your lawyers, sit with them. These are complicated issues, very fact-bound. Generally speaking, a timely filed application postpones your 180 days to the date of the denial of that timely filed application, not the date of the I-94. Okay?
Okay. Okay, thank you, sir.
You're welcome. Okay, let's, we got two more raised hands and then we'll start the new questions. North Carolina.
Hey, Mr. Khanna, this is Kunal. I have a question, but I haven't posted it in the Twitter or the.
Let me ask you to hold. Then we'll take you in the next batch. Okay. I'm gonna put your hand down. Raise it again. Okay. Let's go on to. I'll start new questions after this. Alabama. Go ahead, please, Alabama.
Hey, Rajiv, I have not posted my question either.
All right. Let me put you down. We'll start again. Anyone has any question, press *5. Anyone has any question, press *5. Anyone has any question, press *5. 1, 2, 3, 4. 4 people so far. 5, 6. 6 people. Okay, guys, make sure you raise your hand because these are the only 6 I'm going to take. No more after this. I got to go on. Okay? 7. And please do us all a favor, keep your questions short. I'm assuming, Vikram, that you're on the phone, and I'll take your questions now rather than reading it off the Twitter account. Okay, so We've got a total of 7 questions. Let's start in the order you guys logged in. California, you are first. California.
Hi, Rajiv. I'm the person who was the banyan tree.
Oh, banyan tree. Okay, I know banyan tree. Old friend.
Yeah.
Go ahead.
Yeah, I had a follow-up question though on the same topic.
Yeah, go ahead.
Yeah, since I already denied my H1 extension, can I just continue working or should I stop working before?
Let me take a look. Give me 1 second. Current I-797 expired December. H-1B extension was filed in October. 2 RFEs. 240-day grace period will be up in August 2015. Well, you can hang on 1 second. Will the clock be reset? Your case got denied.
Yeah, it just got denied. Like,
okay, yeah, you cannot continue working. You cannot continue working. No. No.
Oh, I cannot?
No.
Oh, okay.
All right.
They haven't got the hard copy yet. I have seen only the online copy.
I think until you get the hard copy, you're okay to work. That's my interpretation.
Okay. But then can they submit a new H1, file a new H1, and based on that, can I continue working?
You cannot work, but they can file a new H1 and you are running the 180-day period from the date of the denial.
Oh, I cannot work.
Nope.
Okay. Okay.
All right.
Okay. Okay.
Good luck.
Thank you.
Good luck. Okay. Let's see. 6 more. This is North Carolina, another old friend. Go ahead, North Carolina.
Hey, Mr. Khanna. So I have a question regarding the EB1 green card for L1A. Regarding the 1-year experience outside, does it have to be managerial experience short, or else just a 1-year experience in the same employer will count?
If you're trying to do EB1C, it's got to be managerial or executive level experience.
Okay. The 1-year experience outside of the US has to be also managerial and executive.
That is correct. Yes, sir.
Okay. And on the similar one, on the same 1-year experience, does it have to be continuous outside of the US in one country where my team resides, or it can be like I can still travel to US and make that 1 year?
Here's how it works. Okay, now I'm speaking from memory. So of necessity, some of this information could be incomplete or incorrect. But from what I remember, there are a couple of things we need to consider if you are traveling frequently to USA. First of all, every day that you are in USA, you'll have to spend an extra day outside USA to complete that 366 days. Okay, so let's say you worked in India for 360 days, then you're short 6 days, then you stayed in USA for 15 days. Now you have to be outside for another 6 days only because you're short 6 days. Okay, so you have to complete that 366 days. But if you are in USA too long, government can probably think, and this is I'm speaking from memory, government can think that you've interrupted your 3-year period. Now your 1-year period. Now you got to start 1 year all over again. So what if you're here for 6 months? Okay, I think you'll have to start 1 year all over again.
Okay, got it.
Okay.
So it's better to keep it to continuous, but if I'm not, basically I have to just count it that the total number of outside days has to be more than 365.
That is correct.
I mean, at least it's good.
I would say 366.
Got it.
Yes.
1 year. Okay, great. So on the same 1-year experience, because of the situation that I'm in, I just wanted to ask is if I have that 1-year experience outside right now, will it reset the visa clock? For I'm in L1A, so I'm in the 5.5 year right now, and my
No. That does not reset your clock in any manner. What you would do is, because if you file your I-140 and you can file your 485 along with it, you get employment authorization.
Okay.
Okay. So you don't worry about L1 anymore because you've got your employment authorization.
Yeah, but if basically that 1 year experience whole thing, if I go outside to get that experience and come back in order to file the EB1, because I don't have the managerial experience outside.
I don't know how that would play out.
Even if I do that,
that needs to be explored. I do not know off the top of my head how that would play out. Okay.
Okay, got it. Got it. I think that's about it from my side.
Good luck, sir.
Thank you.
You're welcome. Moving on to Alabama. A lot of Alabama today. Go ahead, Alabama, number 2.
Hey, Rajiv, this is Suraj again. I'm on H1B. I had my I-140 approved last May.
Okay.
My girlfriend visited me last year, October, and the second time in December. On December, we got married. She went back to Australia. She's a permanent resident in Australia, but still a citizenship of Nepal. She wants to come here in S4 now, and she has already taken the date. So do I need to include my OPT documents and everything when she applies for the S4?
Let me try to understand this question. I'm a little lost because we have a lot of facts, but I'm not clear about it. Let's just make sure I understand the question. You got married to your girlfriend who is, and did you apply for her H4 change of status or no?
No, she is in Nepal right now. She will be applying for the S4 from Nepal.
When she was in USA, how was she here? Was she visiting on a tourist visa, student visa? How was she here?
She was here in a tourist visa, and we decided to get married, but she go back to Australia.
Okay. Now, as far as getting her H4 is concerned, you don't need to send her anything that has to do with your F1 status. You only have to send her the H1 documentation.
Okay. Do I need to input her documents from Sydney about her bank balance, degrees, anything?
Just go over the State Department's website in Nepal, see what documents they need for her to bring in. It should be on their website. Send her with those documents, nothing more. But remember, consulate can always ask for more.
Okay. So what about if they ask for our long distance relationship? How can we provide a document, supporting documents for that? How are you maintaining the relationship of our wife?
That is again a very fact-bound question. If you were Skyping or you were calling each other constantly or writing cute little emails, you know how people do. Any of that you could bring out and show to the government if that question is raised. My bigger concern is this. Consulates can take objection that she entered USA using a tourist visa when her intention may not have been to be a tourist. If the idea of marriage came up suddenly and without pre-planning, that's good. Make sure when she goes to the consulate, she answers all their questions truthfully. Okay?
Sure. It was a surprise. I proposed her in the airport. She was not knowing when she got here. So
very good. That's the perfect scenario. Very good. Well, congratulations, sir.
Yeah, one more question, Rajiv. So now she has a date on the June the 30th for the interview. Should I wait to file my 485 until she gets the visa and enter the United States? Is there any reason that won't
no,
for
you don't have to
on the petrol?
You don't have to wait if you don't want to, but if you want to wait, that's up to you. It's really purely a discretionary decision. I cannot say that one is better than the other. Okay.
Okay, so I'm just worried in the border if she is asked that okay, your husband has already filed the 485.
That's no problem. That's no problem. That's no problem. H1 and H4 are dual intent. H1 and H4 are dual intent visas. They allow you to file a green card. Okay? I gotta go on to my next question.
Thank you.
You're welcome. Good luck.
Thanks.
Situation in Nepal is still pretty bad, guys. I'm told that they're still getting earthquakes after what, a couple of months, month and a half, something like that. Sucks. All right, let's go to Georgia. Georgia, go ahead, please. Georgia.
Hi Rajiv, hi Rajiv.
Hello, sir.
I have a question regarding EAD. I have a EAD and it's expired, so I applied for renewal. And at the same time, I have my own company, which is running a couple of employees. So, is there any means reason to stop working the company, or I can run the company?
Well, that's the problem with these EADs. If you have no EAD, you cannot work. EAD extension does not give you the interim right to work. So the answer is yes,
Right.
you have to stop working.
Yeah, like I already stopped working for the employer A, but
Also running
I
the
have my
company.
own company.
Same thing. It's unauthorized employment to run your own company.
So I can't run the company also?
In my opinion, no, sir. Not until the new EAD comes.
So the people who are working, I can't even pay it to them, or
In my opinion, no, you cannot.
okay.
Okay, but you can assign that
Okay.
right to somebody else. Somebody else can do it for you.
Okay.
All right.
All right. Means it's still the processing is going on, so still I can't pay it to the employees or something.
No, the answer is no, because you don't have any EAD.
Okay.
Good luck.
All right, Rajiv. Thank you.
You're welcome. Okay, 3 more questions, guys. Please don't raise any more hands. I have to go. There is an unknown caller, probably a voice over IP.
Hi, Rajiv.
Yes, sir.
I have a question.
Mhm.
I'm on a TN visa as a contractor,
Okay.
and while I'm working, can I simultaneously start a company?
Well, that question is very open-ended. Start a company. When you say start a company, what do you mean? Just incorporate or actually incorporate and do business?
Actually, either start a sole proprietorship or an incorporation and actually do business.
You cannot. TN does not allow that as far as I know.
Oh, okay. So if it is just starting a company and which doesn't do any business, then
That's okay because you're not working. Incorporation by itself is not work. Work is basically unauthorized employment is employment with remuneration either in cash or in kind. Okay. If you're not working, there is no violation of any law. All right.
Okay, perfect.
Good luck, sir.
Thank you.
You're welcome. Last question. Let's see. This is Texas again. I think it's an old friend. Texas, what is it?
Yes, sir, Raju, sir. I'm the question number 90, Bob. If my case was denied, the H1 was denied. When if I open an NPR or new H1, and then if it gets approved within, let's say, 30 days or 45 days, will that, if I get the approval by then, is that something I could stay in the US, or I have to leave and get a new I-94, valid I-94?
Well, that depends. That depends. If USCIS finds no violation, no gap in your status, they should approve it with an I-94 without you having to leave USA. Okay.
Okay, so it depends on the approval. When I get the approval,
then you will know. Yes.
Okay.
But your lawyers can predict whether you're going to be able to get an I-94 if the MTR is approved. Okay.
Okay. Thank you, sir.
Good luck. Okay. Well, in between, there's one more question. So this is the very last question, guys. I really got to go. New Jersey, go ahead. New Jersey.
Yeah, hi, Rajiv.
Yeah. Hello.
Yeah, I have a question. It's regarding question number 7.
7. 1 second, sir. 7. You had the question about disability benefits, and I posted it. Did you see my blog posting?
I did, but actually my question was, your question means, let's say the person is in the process of transferring, going status from H1 to H4 EAD.
Okay.
Is he able to? Is he eligible for that, for disability benefits or not?
No, because anybody who is even a green card holder, if they take mean tested benefits that are forbidden, can be subject to deportation. So be careful with that. Um, I've put a blog entry up in the discussion that we have on the forums. And look at the end of it. I have put a link to the blog entry. Review it. That should tell you. In my view, it looks suspect to me. It looks like a mean tested benefit that could cause immigration problems.
So the person should not claim that thing, right? You're saying
that's what it looks like to me. I mean, you can certainly talk to the administrators of the program, see what they say, but don't take their word for it. Check with them, and then get back with me here in the conference, and we can discuss it further. Okay.
I checked with the disability benefits, department here in New Jersey, and they are saying this check with immigration persons, who knows the immigration. We are not dealing with the H1B things and all those things.
That's not the problem. I want you to review my blog entry, compare it with what the program says, compare it with what the admins say, then come back to me in 2 weeks. We'll talk. Okay?
Okay. All right, sir. Thank you so much.
Good luck, sir. Guys, good talking with all of you. I'll see you again in 2 weeks. As always, it is a pleasure and a delight to be able to speak with all of you. Take good care. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.